Moving on, now let us see the law on occupiers liability in Malaysia by having the benchmark and comparative law with other countries. The Occupiers Liability Law in England is based on the legislation. Firstly, we have the Occupiers Liability Act 1957, which provides all lawful visitor, only those who entered with consent of the occupier, to be owed the common duty of care. It does not alter the rules of the common law as to the persons on whom the duty is owed. However, this act only limits to the injuries that arise due to the static condition of the premise and not to include the activities that will be done on the premises. Then, further, in 1984, they had amended the Occupiers Liability Act to include the duty to the trespasser, as the occupier also owed a duty of common humanity after the passing of the case of British Railway Boards and Heritage. So, these had replaced the rules of the common law, and now the duty is owed to the visitors and also the non visitors. In Malaysia, we do not have any corresponding statute on occupiers' liability, so we follow the common law principles. But just a note that Malaysia is following the English cases only up to 1965. So we categorize all the entrants into different types which have different standard of care. Firstly, the contractual entrants. The occupier owed reasonable care to avoid any foreseeable injury towards them. Secondly, we have invitee, persons with common interests for the occupier and both the customer at certain premises. The duty is to prevent them from being exposed to any unusual danger. Next, we have licensee, people with express or implied permission to be on the premise as well, but their presence usually does not have any interest towards the occupier because the occupier is just allowing them in matter of grace. So the duty is to prevent them from being exposed to any concealed danger. And last but not least, Malaysia also recognize the duty owed to the trespasser based on the reasonable steps of common humanity to avoid any danger that may arise. However, we also put several factors to be considered, which is the occupier's knowledge on the presence of the trespasser, whether their presence is reasonably foreseeable or not, and also the occupier financial limitations. So generally, we owe duty to all type of entrance. Since we are following the common law principles, usually the cases arises in Malaysia will be under the negligence claim on occupiers liability. Interestingly, in Canada, we have 6 out of 9 provinces enacting occupiers liability legislation. However, they have different definition as to the extent of the trespasser, even different standard of care. For instance, in Alberta, the Act limits liability to trespassers which have willful or reckless misconduct. But in Manitoba, they didn't even recognize the trespassers, the duty to the trespasser. And the comprehensiveness of law in Canada, it does not limit the injury arising from the condition of the premise, but also activities and conduct of third parties on the private premises. Unlike other countries such as England, it provides much wider scope. And interestingly, in other provinces such as New Brunswick, it had opted to do away from this legislation and prefer negligence standards based on the judicial legislation and ordinary law of negligence. So we have different type of law being applied on occupiers liability in Canada. So the occupiers liability law in Australia is much more complicated than others because they have different jurisdictions and certain part of it accepted common law principles and others has their own legislation. So main point here is firstly, they has the single standard of reasonable care towards lawful entrance and they does not necessarily need to classify the different type of entrance, but they owe general duty of reasonable care, and this reasonable vary from circumstances on how the person enter into the premises. Secondly, the extent of the trespasser different according to the jurisdiction because in Western Australia, let's say, they owe the lower duty to the persons who enter the premises as a trespasser but with the intentions to commit any offence punishable by imprisonment. And thirdly, in Australia, they also recognize injury arising from the static or activities on the premises. So it is much more wider than England and Malaysia, but quite limited than Canada just now. In Ireland, the occupiers liability law does not differ much from Malaysia and England because they recognize the same type of entrance, and the nature of duty owed in Ireland is based on the Occupiers Liability Act 1995. However, interestingly, here the trespasser was not afforded any protection if the wrongdoing was committed by him and his presence was unanticipated and it is impossible for the occupier to cater because the entrant should not have been there. So they also differentiate between the in-nonsense and burglar type of trespasses in justifying the different treatment based on the case of McNamara and ESB. Lastly, in Scotland, the Occupiers Liability Act 1960 had been enacted, and it applies same duty of care to all entrances, including the trespasser. But it is much more wider as the act applies not only to the personal injury but also to damage to property on the premises and include the property of the persons. So we might be wondering what types of precautions that need to be taken by the occupier so that they will not be liable and they can strike the balance between risk of danger of the amusement devices they have. So in Malaysia, we have the benchmark on guidelines on the safety management of amusement park devices that have been passed in 2008 by DOSH, Department of Occupational Safety and Health under Ministry of Human Resources Malaysia. So this guideline had further outlined the risk assessment and risk control process. It also sets safety standards for the design, constructions, maintenance, and even inspections of the amusement devices at the amusement park and fairs. Other countries such as Australia and United Kingdom also have the same amusement device regulations. So, for instance, in general inspections provision, it further mentions every amusement device will have to go through thorough inspections in appropriate intervals that will be done by appropriate authority. This will further help to strike the balance of precautions need to be taken by the occupier. As to wrap up, most of the countries have the same type of entrance following the common law principles. However, the law there may develop accordingly, and some of them even opted to deal with the laws of negligence and do not have corresponding statute on it. But some of the countries even deal by having specific statutes on Occupiers Liability Act. So it depends actually on the legislature and even the courts in particular jurisdiction to specify the details and make the act to become comprehensive enough.